So today I am joined by Henry Straw. He's one of our solicitors here at IDR Law, and we're going to be having a look at, the considerations with regards to a 1975 Act claim. So, going ahead there. So let's look at what we'll be covering. So I'm gonna take us through inheritance disputes and a bit of context, a bit of background in terms of the rise of these. Henry's then going to take us through the preliminary considerations when faced with one of these types of claims and how we can identify those red flags with our claim checker tool. So it's going to be a bit of a practical session, and we're going to use an actual case study and give it a walkthrough with the claim checker. So that'll be quite interesting. Please do, if you've got any questions along the way, you can put them in the chat, but we will be sharing our details at the end so you can direct any queries to myself or Henry. Okay, so I'm going to kick off now with the inheritance disputes and a bit of background in terms of the rise of these to give this session a bit of context. So it'll be no surprise to any of you on the call today that claims are rising and they continue to rise. We discuss it a lot here at IDR Law. If you've been to our contentious clinics in the past, you'll know that it's something that we highlight quite frequently. Just a few months ago, The Guardian reported on the record volume of emotionally charged court cases, which were the result of these types of family arguments. As you can see from my slide here, there's a stat there, 10,000 people dispute wills across the UK every single year. And 1 in 3 of us are actually relying on an inheritance. So actually relying on that inheritance to, discharge debt, move home, or retire. A lot of people are relying on that inheritance to have that comfortable retirement in later life. So the growth has been driven by the passing of wealth, so the baby boomer generation and property. So there's been a huge rise in property prices over the past 50 years, which has resulted in a large amount of wealth being amassed across the oldest generation. Another point here, you'll see blended families, not a surprise to many of you, I'm sure. The average, blended families results from divorce, obviously, and divorce rates are rising. The average marriage now lasts around 12 years, which, gosh, I was quite shocked about. I'm doing okay. I'm 13 years in, so I'm over that 12 years mark. So obviously the result in divorce is the blended family, people remarrying, having families later on. Another cause is dementia rates. So dementia rates are increasing, unfortunately. And according to the NHS, there are now 850k people now living with the disease, which is, I'm sure many of you will have heard the rates, and it is actually quite baffling. So therefore, there is a number of wills executed and open to dispute. And obviously this will continue to increase when taking all these kind of statistics and considerations at play. The pandemic has also led to a cost of living crisis. So that puts a lot of financial pressure on people, meaning the reliance on getting that inheritance is far greater. And when those bequests don't arrive, that's when these types of problems occur, relationships break down, and people start to crack. Oh, sorry. It's not moved along. So I thought here it might just be worth looking at what these type of people look like. So when we created our claim checker and our new websites, in fact, that are now live, we did a lot of research into the type of people who are making these claims. Obviously, we've got lots and lots of data on this. We've had 5,000 inquiries across the years. So we've been able to look at trends and look at what these people look like. And we hosted lots of various user interviews and did a lot of UX and user research around this. Now, it's not really a shock at what these people look like. But one thing that I think you need to remember is an inheritance dispute won't come along twice. It's very rare. It's probably the first time and only time that the people in these situations will ever deal with something like this. So it's quite a shock. It's quite a, it's something that would be quite something to deal with for them. And also, someone's died and they'll be grieving, so everything's really quite emotionally charged. Someone is then unhappy with the inheritance arrangements, and it can cause these kind of communication breakdowns, sibling disputes, and family dynamics are often at play in these kind of situations. And we probably all have an element of knowing about those. So what do these kind of people want to happen when they're in these types of situations, these rare situations that they've never found themselves in before? They're usually they need to seek information. They haven't got the information, so they will need to seek it. They'll want to speak to a solicitor, probably a family solicitor, because they'll trust them. And they want to know if anything can be done. And the key questions here that people usually ask is, will it be successful? How much is this going to cost? So at IDR, we deal with lots of different types of claims. And in putting this presentation together, I actually had a look at how many 1975 Act claims we have actually dealt with over the past 12 months. And over the past 12 months, the percentage of 1975 Act claims was 38%. So that made up so the 38% made up of the 1975 Act claims that we got through. So what I'll do now is I'll hand over to Henry, and he can discuss with you the preliminary, I find that word very difficult to pronounce, considerations when faced with claims under this Act, before we move on to going through that real life case study for you. So Henry, you'll have to do your next slide here for me, please.
Okay, no problem. I think you've gone one too far.
There you go.
There we are. Perfect. Thank you very much. Yes. Yeah. Welcome everyone. Thanks for joining. So, yeah, as Lindsay's sort of highlighted, really, these sort of claims are on the rise with those sort of expectations that Lindsay's mentioned, and so I'm sure that everybody on this call has had clients or prospective clients come to them with a potential claim, and then you've either kind of referred it on to somebody that you work with, or perhaps not known where to turn. So purpose really of this this webinar is, as Lindsay touched on, is to kind of give it a bit of an insight into what contentious probate lawyers might be looking at when those sort of inquiries or referrals do come through, and those preliminary considerations that Lindsay mentioned. So normally there's a promise of a sort of whistle-stop tour at this stage, but I can't make that promise. But hopefully you'll come away with some benefit and have a little bit more of an insight into the work that's undertaken in when those inquiries initially come through. As is clear from the slides and from what's been said so far, this session will focus on the 75 Act, but it's often the case that when prospective clients do come forward and talk to us about their circumstances and their potential claim, that often it might start with what they believe to be a 75 Act claim, but there are potentially other sort of avenues that we might end up looking at as well. So as a general rule, from our standpoint, and I suppose other contentious probate lawyers, I assume, would probably say the same, that the more information and context that we have up front is always going to be helpful. So when we're presented with a potential 75 Act claim or a potential applicant, the starting point is always to look at the Act itself, and the initial step is to consider whether the potential applicant is actually eligible to pursue a claim under the 75 Act. So, as it states on the slide there, the 75 Act, as I'm sure you're all aware, is a sort of platform really for eligible applicants to pursue a claim against a deceased person's estate, where that applicant believes that the deceased person's will, or in the case of an intestacy, the rules of intestacy, fails to provide that applicant with reasonable financial provision. But before we can consider what reasonable financial provision is and whether that's been made, the very first hurdle is to consider, as I say, is whether the potential applicant is actually eligible. So Section 1 of the Act does set out who qualifies as an eligible applicant under the Act. So again, I'll sort of trundle through these, but I'm sure most of you are familiar. So we've got spouse or civil partner of the deceased, former spouse or former civil partner, on the assumption that they haven't entered into a subsequent marriage or civil partnership, a child of the deceased, any person who's treated as a child of the deceased, any person who immediately before the death of the deceased was being maintained either wholly or partly by the deceased. And then we've also got cohabitees as well, which our case study will sort of centre around a claim by a cohabitee, which came across our desk. So the first, as I said, the first hurdle will be that eligibility. If the prospective client sort of ticks that box, then it's a case of considering, right, okay, well, what are the court going to look at in determining these claims? I mean, naturally, many of these claims tend to settle before we get to court proceedings, but it's always sensible from a practitioner's perspective to look at, right, okay, well, if this does proceed all the way to a trial, what will the court be looking at, and then sort of work backwards from there, really. So as it says on the slide there, the court will ask, has the claimant or applicant been left with reasonable financial provision from the deceased estate? And if not, what is reasonable financial provision in the circumstances? Now, where there are different sort of tests for different categories of claimant. So where we're talking about claims by spouses or civil partners, it's sort of reasonable financial provision generally, and then other applicants, it'll be reasonable financial provision for the purposes of their maintenance. So the idea of this slide and this sort of initial section from me is really just to sort of set the scene and take a kind of bird's eye view look at what we might consider when these inquiries come in. So Lindsay, could you move on to the next slide for me, please?
Yeah. It seems to be sticking today, sorry.
That's okay, thank you. So yeah, once we've considered whether they're eligible, and then it's a case of, right, okay, we need to start considering or look at whether they've been left reasonable financial provision. One of the other things that we will also look at from the outset, or consider from the outset, is the powers of the court to make orders. So they're set out on the slide there, and they're set out in Section 2 of the Act. Now, it's important to have this in mind as well, because there are certain factors that we will look at in the early stages of a claim, which will influence strategy and how we might look at advancing and sort of progressing these claims. So it's always helpful as well to keep that in mind. And as contentious probate practitioners, that's certainly what we would be doing. Lindsay, again, if you could. Perfect, thank you. And then we come to the Section 3 factors. I think this is the section that most practitioners, whether contentious or non-contentious, would be sort of most familiar with, really. And this provides the framework, really, for contentious probate practitioners and judges alike to consider and assess the merits of any potential claim. So again, these are always factors that we will be looking at from the outset, and when considering the merits of any prospective claim. So as it says on the slide there, we've got the finances and resources of all claimants' beneficiaries now and in the future, the obligations and responsibilities the deceased had to any applicant or beneficiary, size and nature of the estate. So referring back to the previous slide about the types of orders that can be made, that would often be dictated by the size and nature of the estate. Any disabilities of any applicant or or beneficiary, and then a sort of catch-all, which is anything else, including the conduct of any party. And then we've also got the manner in which the applicant was being, or in which he might expect to be educated or trained. So again, that's another factor that in certain circumstances will apply depending on the category of claimant there. So Lindsay, can you just move on again for me, please? Thank you. Okay, so using our sort of claim checker as the foundation, really, the claim checker does ask a number of the sort of pertinent questions, really, when considering those preliminary stages. And one of the things that it certainly tries to do is to check whether the applicant has or the potential applicant has legal standing to pursue a claim, and ultimately, that's going to be a really key consideration, because if they don't, then that claim's not going to get off the ground. So the claim check is a useful starting point for establishing exactly that. And the benefit, I suppose, to those of you who are non-contentious private client practitioners, is that if you are approached by a prospective client who believes they may have a claim, then you can utilize the claim checker with the client in a meeting of your own, or you can sort of direct them to the claim checker, and they can then you can with them, or they can do it individually. They can fill in the questions and respond to the questions, and then it will prepare a report for them at the end, which gives them an indication of whether they may or may not have a claim. So as Lindsay touched on, we'll run through a case study shortly, but the sort of key considerations, or some of them, are outlined on this initial slide here. So relationship to the deceased, again, that is is targeted at establishing whether or not the potential applicant has legal standing to pursue a claim. Date of death, again, that's always going to be important, whether that's for a 75 Act claim, it will play a part, or whether for probate claims, such as on there. The time limitation in 75 Act claims, the clock starts ticking once probate has been granted, and that's again, as you'll see on the slide there, one of the questions that's also asked by the claim checker. And once probate has been issued, or granted letters of administration, in the case of an intestacy, there's then 6 months for that applicant to issue their claim if they believe there is merit in doing so. So again, just showing that they are sort of pertinent questions that ought to really be asked at the outset, but they are already sort of built into this to the claim checker. With respect to of the sort of date of death as well, that's important for us to consider when at the outset as well, because that will potentially influence the evidence that might be available in the case. And a lot of these claims will always be sort of evidence driven, and so if we're dealing with a death that occurred many years ago, the quality and availability of that evidence might be lacking somewhat. So that is again another sort of pertinent point to be asked at the outset. Domicile as well, age of the deceased as well, that's that will also be relevant, and it may not specifically be that overly relevant in the context of 75 Act claims, but it might also potentially open a door to the possibility of exploring a probate claim as well. So again, just important information for us as contentious probate practitioners to know at the outset. And then domicile as well, so a bit like eligibility and legal standing. If the deceased individual was not domiciled in England and Wales, then they're not going to be able to rely on the 75 Act. So it's important for us to important for us to establish that issue of domicile, or to consider that issue of domicile at the outset too. So Lindsay, if you can move on, please.
Yeah.
That hasn't moved on my screen, sorry.
Oh, sorry.
Oh, there we are. It's come back. It's obviously just a bit of a delay.
It's a bit slow, sorry.
Yeah, no worries. Yeah, then further considerations. So, is there a will? Again, that's a pretty obvious one, and that will be central to sort of assessing the merits of any 75 Act claim. Ultimately, we're coming back to whether the applicant has been left reasonable financial provision. So, if they've been left nothing, then that's obviously perhaps a little bit more clear cut potentially, depending on all the circumstances. But if they have been left something, then again that might require a bit more assessment. The estate value, again, it's important for us to consider that at the outset. As I touched on earlier, the estate value and the makeup of the estate can influence the orders that might be available if the claim proceeds through to trial, but also from a sort of cost benefit analysis and funding perspective, it will be important to consider that at the outset, i.e. Is the sort of financially is the sort of financial merit in the potential applicant pursuing a claim? Is there enough money in the pot for them to for them to go after, and particularly when you take into account how costly these claims can be. As is sort of touched on there as well, funding is again linked to that, and the estate value can in some cases also influence the sort of funding of options available to the potential applicant as well. So that will be another key consideration. Asset breakdown, again, very important to consider which assets actually sort of form part of the death estate, and which don't, which might pass by survivorship, for instance. Again, that sort of informs the kind of cost benefit analysis. And also, depending on the breakdown of the assets, that can influence what settlement options we might have available to us too. You also asked the question on the claim checker: do you inherit under the will? Again, like the question, is there a will? That will that goes directly to the sort of assessment of the merits of any potential claim. And then there's also a question about inheriting under an earlier will, which again will influence how we potentially what strategy we might adopt in dealing with these claims, and whether a claim is even possible. Other beneficiaries, again, as it says there, it's important to know who you're sort of competing against. I mean, in the context of 75 Act claims, it's sort of generally accepted that spouses will often be kind of treated favorably. So, if you're an adult child, for instance, competing against a spouse, then that can potentially impact the strength of your claim, and is certainly a factor that would have to be considered. And again, that all leads into that sort of early cost benefit analysis, so that the prospective client can give some consideration as to whether it is definitely something that they want to go ahead with. And also the Section 3 factors. One of the Section 3 factors do directly relate to or directly address the other beneficiaries and any other sort of potential applicants, and their circumstances, particularly financial circumstances, will be relevant factors when considering the merits of pursuing a claim. Next slide, Lindsay, please.
Oh, so, I think this is where we move on to the case study, Henry.
It is indeed, yeah. So I think
shall I
pull up the claim checker? Is that right?
Yeah, I'll go across to the claim checker. So I'm accessing this via the IDRN space, which we'll share details for following the session, which is completely free to use, and the claim checker sits on here. So this is where you can, if you've got a client with one of these issues, you can actually use it for free via the IDRN. Do you want me to just go straight into the demo using the
yeah,
study,
I mean, we can do.
Henry?
So I mean, yeah, it might be helpful. So the context to this case study is as I touched on earlier, is a 75 Act claim by a cohabitee. So it's a real life example that came across our desk. The names have obviously been been changed and some of the facts kind of slightly tweaked, just for the purpose of this webinar. But so yeah, the sort of prospective client in this case, a chap called Michael Smith, again for the purpose of the webinar. Deceased is Richard Johnson. They were cohabiting partners, so they weren't married or civil partners, although they had discussed getting married, but unfortunately Richard, deceased mother, didn't approve of their relationship, and so it was kind of very much put on the back burner, and they never actually went ahead with it before Richard sadly passed away. Again, similarly, again, one of the sort of common circumstances that crops up, Richard had actually prepared a will, but had never actually got round to signing it. He'd suffered an illness, and so he commenced that process, but then actually didn't get around to signing it, which is, incredibly frustrating for all concerned, and does, often then lead to these sort of difficult situations that we're then having to address and try and untangle. Richard then died quite quickly and quite unexpectedly. So even though he had been quite unwell, his death was very sudden, and that is ultimately what prevented him from getting that will signed and executed. At the time of Richard's death, he and Michael had lived together in Michael's property for approximately 9 years, and Richard died without a spouse, or even though they had spoken about marriage, they hadn't gone ahead with that, and they didn't have Richard didn't have any children either, meaning that his estate passed to his surviving mother. So that's the context of the case study. So yeah, we can just sort of scoot through and provide a demo of how this will work.
Yeah, jump into it now. It's probably worth noting that if a client's doing this on their own, there is handy guidance throughout the claim checker itself. So as you can see via these accordions on the side, and it just helps them understand and answer the questions, because some of the questions may be to a lay person, it may not be understandable as to how they would get the information or what the answer could be. So there is guidance throughout the form. So that's just what the right hand side of the screen shows, just to let you know, just before we kick off with this. Okay, so who has passed away? So we know from what Henry just said, this is Richard Johnson. What was your relationship to them? So from the understanding from Henry, it was cohabitate. The date of death, for the purposes of this, was the 1st of June 2024, and their age at death was 64. Has probate been granted? Yes, probate has been issued.
Which I think is probably unlikely given the delays, and if the death had actually occurred on the 1st of June, but there we are.
Handy. When was probate granted? So within the last 6 months, and we know that he was domiciled in England and Wales. So then we go through to the next section. And this section, as you can see at the top, it's got like a progress indicator. So the first section was about the deceased, and the next section, the inheritance, the relationship, and then the completion of the assessment. So is the estate being distributed according to the will? No.
No, he died intestate, unfortunately. Yeah.
And do we know the estate value? Yes, we do. The estate value here is 500 to $1 million, so a pretty hefty estate there. What's in the estate? We are told it's property and cash. Your inheritance. So do you inherit under the will you are disputing? No, unfortunately, he does not. And did he inherit under an earlier will? No, unfortunately, he didn't. How many other beneficiaries are there? Well, we know there's one, because it's the mother.
Yep.
Why are you unhappy with the situation? So he's unhappy with what he's been received, and promises haven't been kept.
Yeah, just below there as well, there's obviously that box just below that, Lindsay, which says,
Yeah,
"Can you describe why you're unhappy?" And again, that's quite a useful section for either you as practitioners or your clients to sort of put additional information in there. I mean, it's often the case in these sort of circumstances that when we speak to people, about these sorts of things, they kind of want to give us the full family history and the war and peace about sibling disputes and all that sort of stuff. But whilst some of that information may not be overly helpful. As a general sort of rule, I think as I touched on earlier, it's often helpful for us to have sort of more context at the outset than and more background information than not enough. And then because if we're not given that information, we don't know that we're missing that information. So yeah, it's helpful for a helpful space really to put additional information in there.
yeah, definitely. Okay, let's move through to the relationship area. So we know we've already established that they were cohabitees. So the length of time cohabiting, obviously, the longer that they are cohabiting, then the stronger the claim, I'm sure, Henry.
Well, it's 2 years essentially. So even though there's a drop-down menu which gives the option for sort of many years, it's the key period is 2 years. So yeah, section 11A confirms that it's the whole period of 2 years ending immediately before the date when the deceased died. So in this case, we've got 9 years where they were cohabiting together. So we're sort of you're well clear of that. But the other sort of stipulation where cohabitees are concerned is that they have to have been living in that household in the same household together, and as if they were a married couple or civil partners as well. So,
Yeah.
Yeah, but again, those sort of prompts down the right-hand side that you've spoken about, Lindsay,
Yeah.
there is a bit of that kind of information given there as well. So yeah, always useful to look at those guidance prompts.
Yeah, certainly. And the next one, we go into financial dependence. So were you reliant on any financial support? Yes, he was. He relied on Richard for, he supported with the property, lived there rent free, paid for all the outgoings. So yes, very much
Yeah, and again,
needed that support.
that's relevant because it's one of the categories of claimant is somebody who is being financially maintained by the deceased. So even if, for instance, you didn't satisfy that sort of 2 year cohabitation period, there's still an argument to say that if you were being allowed to live rent free in the property and you were receiving other financial support from the deceased, then that is potentially an avenue for another section of the act that you might be able to rely on. So again, all of these questions have been deliberately devised so that we can gather all relevant information early on, and that will help to steer where we might take things.
Yeah. And so the next one, physical or mental health. So this is a no here.
It is, yeah. Again, it's one of the section 3 factors, though. So again, reverting back to what we said earlier and about the things that the court will consider, that is one of the relevant factors. So that's why that's included there.
Okay. And then we go into next, and this is where we complete the assessment. So just ask a question here. How would you like to proceed? So it just gives our triage. It's like going back to that box that Henry talked about before. It's giving us a bit more information so that when we make contact, we know what we're dealing with. But at this stage, I'm just going to put gathering information. And then I will add the details. So I'll put Michael Smith, and I'll just put test. So our triage are aware it's a test at this.com. I'll just put fake number in. And then once we hit submit here, we'll be taken across to the outcome report. Yes, it worked, thankfully. And so this is how the report works. So at the top of the report, it's color coded. So we've got green blocks that indicate that the circumstances would strengthen the likelihood of the dispute. Yellow blocks, bit of uncertainty around the likelihood. Red blocks, the circumstances would weaken. And the blue blocks are just for that kind of general information only. So we'll just whiz you through this, and I'll just highlight a couple of points. We can see here that the date of death, so first and sixth, because it was a recent death, obviously that's passed as a likely success here. Uncertainty around the will situation, because there is no will. Estate value being high gives another likelihood of success. I don't know if you want to say anything around any of these before I whiz down to the 1975 Act.
Not really. I mean,
Henry.
there's a yeah. I mean, I think the color coding and explanation is useful. I mean, it will give you a sort of indication, as Lindsay's about to come to, as to whether whether you can make a claim or not. That will be a yes, no, or a maybe. But invariably these sort of reports will provide answers that it won't always necessarily be green, and so a kind of nailed on claim. And so it is, this is principally designed as we've touched on, is as a starting point, really, just to sort of give you an indication and check that you're not potentially kind of wasting your time in then going ahead and speaking with a solicitor. So it gives you a preliminary indication and gives you also an insight into some of the bits that you might then be asked about, or speak with that you might then speak with a solicitor about, should you decide to take the claim forward. So it's a pretty handy report.
Yeah, and it just gives that reassurance. So we had somebody use it recently who was quite worried and nervous about going to a solicitor, because they were worried about the cost and the likelihood of success. And I think it just gives that, it just gives those kind of people that added level of reassurance, and gives them that. It's kind of that initial call taken away. This is the initial call. I think you said that the other day, Henry. Quite a nice way to describe it. So let's move down to the 1975 Act. So as you can see here, it does give a yes, no, or maybe on making a claim under the Act, and this one is yes. And you were probably aware of why it said yes. The grant of probate was within deadline, domicile, relationship, the length of time cohabiting. So all greens there. So essentially what you can then do with that, you can keep a copy for your own file, you can forward a copy to the client so they have their own documentation to then go away and discuss it through with any family members before taking those next steps. So it's quite handy in terms of that as well. Okay, so should we move back over to the presentation, Henry?
Sure, yeah, by all means. So back to me, isn't it? Just a few points to round off, really. In that, so I mean, once you've got that report, as I say, it gives you a helpful indication, really, of whether, as a potential applicant, you have standing, and whether you might therefore be able to pursue a claim. I would just add that being an eligible applicant does not automatically mean that you are entitled to provision from an estate. So just because your report comes back and says yes, you can make a claim, doesn't necessarily mean that the follow-on advice will be yes, you should make a claim. So that's just one of the sort of key points to highlight at the outset, really. But nonetheless, Claim Checker, quite an informal way of at least getting an indication of whether you can claim at the outset. And then from there, it will be ideally speaking with a specialist contentious probate practitioner, whether that's our firm or elsewhere, and then it will be a process of kind of assessing the merits of that individual's claim. So I mean, with regard to our case study, and just kind of reverting back to that, the relevant test, as I touched on earlier, or the relevant standard by which there'd be a judge, was whether they've been left reasonable financial provision for the purpose of their maintenance. I mean, what constitutes maintenance was covered in one of our previous webinars on the 75 Act, so that might be worth jumping back into if that is a particular query that you might have. And I won't go into detail on that in this situation, but as you'll appreciate, what is reasonable financial provision for the purpose of somebody's maintenance. That will be specific to that individual, and that will require an assessment of that individual's financial circumstances. And so normally, as part of our kind of phase one in investigation, as we refer to it, we will do a deep dive into that potential applicant's financial circumstances, both now and in the future. It's also worth remembering that the applicant, if they were to pursue a claim, then they'll need to sort of evidence that financial need as well. So it's not just simply the case of saying, oh yes, I have a sort of monthly shortfall every month. You'll need to be you need to be able to evidence as the applicant where how that shortfall has arisen, and provide that sort of financial disclosure. It's worth remembering as well, whilst sort of touching on that Section 3.5 of the Act says that it will be the financial circumstances of the applicant at the time of the final hearing as well, which will ultimately be considered if it gets that far, and not the financial circumstances of the applicant at the time of death, for instance. But yeah, the onus will be on the applicant to show that they haven't been left with reasonable financial provision for his or her maintenance. And yeah, that will typically be done by an assessment of the financial circumstances and the evidence of the same. But it's not only the financial circumstances that the court will take into account, and that's that can be evidenced by the sort of breadth of the Section 3 factors. Section 3G, for example, that catch-all that I mentioned earlier, that's any other matter, including the conduct of the applicant or any other person, which in the circumstances of the case, the court may consider relevant. So there can be sort of lots of factors that or issues that can sort of find their way into these cases. But ultimately, because this is a claim for financial provision, it follows that that quite a lot of the preliminary focus will be understanding whether the potential applicant has a financial need, and therefore whether they ought to pursue a claim. And then,
okay.
as it says at the bottom there, claims do turn on their own facts. But yeah, as the point that we made as well, that the claim checker asks those sort of key preliminary questions on whether a claim is viable, and that's a useful starting point, and one which can be done at without cost to your clients. I mean, it's always a sort of typical lawyer's response to sort of end these things by saying that, oh well, everything will ultimately turn on, the cases will ultimately turn on their own facts. But it is true, and hopefully you'll see from those Section 3 factors alone that that's ultimately why these cases do turn on their own facts. But it's hopefully this webinar, I mean, Lindsay will sort of round things off momentarily, but hopefully it's given a little bit of an insight into what we would be looking for, or what we'd be looking at when these inquiries or referrals come through to us, and the work that we might do in those preliminary stages. And equally, hopefully that you might have been able to see the sort of potential value in using that claims checker as a tool at the outset too.
Thank you, Henry.
No worries.
Okay, so yeah, I won't keep you too long now. Just to round up, as we've gone into quite depth on the claim checker, I suppose it wouldn't be right not to let you know where to find it. So you can access the claim checker through the IDRN. So the IDRN is our referral and support network for all of our referrers and anybody working in the wills and probate industry. It's got lots of, not only has it got the claim checker on there, it's got lots of training materials on lots of other topics. It's completely free to register. It only takes a moment. And you'll find the claim checker in the checker claim area, which you can use with your client. If you want to send your client off to use it themselves, then you can send them to our website, our idrlaw.co.uk website, and they can check a claim themselves through that area. Or a lot of our referrers are now hosting the claim checker on their own site. So how that works is it's completely white labeled to your own site. You're provided with an embed link, and it goes on a landing page area of your own website. The unique embed link means that we can track any referrals coming through from your organisation. We can set you up on a 10% fee share. So any cases that are billed and complete for any referrals that you send through via the claim checker or any other way, you'll receive a 10% fee share on that. We are also adding a mini survey at the end of the claim checker that prompts them to return back to your website should they need any further estate administration, i.e. LPAs, make a will. Obviously, we don't do that kind of work, so we're happy to prompt them to go back through to you. So it ultimately it can generate leads for you as well. So yeah, please do divert any questions through to myself or Henry. All things claim checker, all things IDRN, direct them to myself. All things legal, please direct them to Henry. And yeah, so we have now, I will wrap this one up for today, but thank you all so much for coming. We are back in the autumn. We're taking August off from the clinic, but this training session will be up on the IDRN later today for any of your colleagues to access. And obviously we've got lots of other training materials on there as well. So thank you. We'll leave you to go and enjoy the sun. Thanks very much, everyone.
Thank you.